Someone make it make sense.
Probably a couple.
Hello. We are back. We've got another update here for Karen Reed. Some new court docs just came out. A couple of these came out like maybe yesterday or whatever, but there's one that just got posted. I don't even know if anyone's had a chance to cover it yet. So we will just get started here. First things first, we have a ruling from Judge Bev on the Commonwealth's motion to compel reciprocal discovery of ARCCA witnesses. So we will take a little look here. Welcome back, Candace. Happy to see you again. For anyone who missed it, we did cover, earlier today, we had a live stream for Lori Vallow. It was MIA and AZ. So we took a look at some of the witnesses that were talked about a lot in her Arizona trial. And in fact, so much so that Judge Boreski even suggested making including in the jury instructions, an instruction regarding these witnesses. And the ones that I'm referencing here are Detective Moffitt and Summer Shiflett. Now, while Melanie Gibb wasn't really brought up in the Arizona trial, she's another one who was MIA for this trial. So we watched, or we listened, because there's no cameras, to Detective Moffitt's testimony from Idaho, to Summer Shiflett's testimony from Idaho, and then we watched Melanie Gibb's first interview with law enforcement, which was really, really interesting. And we learned got some new details there as well. Some other people that were involved. And we're going to do another follow-up probably tomorrow with Lori's Inner Circle. And that's going to include an interview with Julie Rowe and Nate Eaton, among other things. So all this, of course, ahead of her Monday trial. They're going to have closing arguments. And I also would expect a verdict that same day, just in the nick of time. And it's a court miracle that Lori and Karen Reed will not overlap. Now, having said that, there will be overlap for the Brandon Boudreaux attempted murder trial, but that one is not starting until May 30th, I don't think. And of course, that to me was not nearly as much of a priority as this particular trial for Charles's death. And so love that, there will be less overlap in any case than what would have happened had Lori gone longer and had Karen started on time. So anyway, it's a court miracle. Welcome, Abby. Happy to see you again. So love this. Bev might restrict ARCCA testimony, but she won't turn down the chance to have Dr. Wolf in her courtroom again. Accurate. Have all of you guys, y'all all seen the Judge Bev doll? If anyone hasn't, let me know, because it is amazing. Hopefully you guys have also seen the Squirrel Crew proposed juror questionnaire as well, because that's also really funny. For the for the Karen Reed trial, we did a revised version that's pretty funny. So okay. And Random Girl, did you ever want a command? I don't think you wanted one, or you would probably have one by now, but let me know if that is not the case. Speaking of Random Girl being a new member, I don't want to be redundant, but I know, people tune in for different streams, so I want to make sure everyone is up to speed who's members. But our next members only live stream will be trivia night, and it will be trivia on famous quotes, first in history, movie trivia, musical theater trivia, trial trivia, and 90s music. So that might be tomorrow, but again, it just sort of depends. I've got to get that all sorted out because it might be that we're prioritizing the Lori stuff ahead again of closing arguments on Monday. So yeah, can't think of anything. Well, if you change your mind, let us know. Let us know. It can be just emojis, it can be a quote, it can be literally anything. So let's take a look here. So the ruling on the Commonwealth's motion to compel reciprocal discovery of ARCCA witnesses. The Commonwealth moves for an order compelling the defendant to produce discovery pertaining to the ARCCA witnesses in compliance with the defendant's obligations under Rule 14. The Commonwealth also requests that the court order the defendant to certify its discovery obligations incomplete and limit or preclude the defendant from requesting that ARCCA conduct any further interview or testing. So this was another thing that was interesting that we learned in that most recent hearing, where it sounds like it's possible they could be engaging in further testing, perhaps to be used in rebuttal. And that made me a little bit nervous, right? Because we all know how if the defense toes the line, on any of this stuff, right? We usually know how Judge Bev's going to rule. So that did make me a little bit nervous. However, again, if it's going to be in rebuttal to Judd Welcher, then that does sort of change things versus just like new testing for their initial opinion. So, okay. So anyway, so after review of the written submissions and oral argument on the motion, the court makes the following ruling. It is hereby ordered that by April 18th, 2025 at 5 p.m., so that would have been yesterday, the defendant is to produce to the Commonwealth any outstanding discovery listed under 1, 2, 3, and 3 of the Commonwealth's motion, and there is a footnote. So that would be all bills, contracts, retainers, engagement letters, or payments that have been created for the defense of Karen Read or provided to or from the Karen Read defense team from March 1st, 2024 to present. All emails, letters, any written correspondence, including text messages at any time between any employee of ARCCA, LLC, and any member of the Karen Read defense team, including Karen Read. All phone ledgers evidencing phone calls or text messages between any employee of ARCCA, LLC, and any member of the Read defense team, including Karen Read at any time. Now, this is the discovery that the defense says they already have. They've already turned it all over. So I'm not surprised this deadline was so soon after the hearing. Okay, so in addition, by April 18th at 5 o'clock p.m., the defendant must disclose to the Commonwealth any oral representation or agreements or understanding regarding anticipated reimbursements or payments to or on behalf of ARCCA between any member of ARCCA or the defense team, including the defendant. Again, that falls under the category of things they said they've already turned over. Now, as far as further testing, all right, it is further ordered that by April 21st, 2025, at 12 p.m., the defendant must disclose to the Commonwealth any testing underway, requested, or contemplated. As to any testing underway, requested, or contemplated that is not completed, the date the testing will be completed, and the results of any testing. After receiving the above discovery, the Commonwealth may move for additional relief. So I will say this is fair in the sense that this is not precluding them from any additional testing. So she's really siding with the defense here that, look, this was fair as to when they were given Judd Welcher's opinion, his report, and that this would be proper for rebuttal. And again, the deadline of April 21st is not for the testing to be completed if it's underway. That they just have to disclose it's underway. So this is very fair. It does make me nervous, though, this bottom line, after receiving the above discovery, the Commonwealth may move for additional relief. So like this doesn't preclude Bev from still stopping it from coming in. So what she's saying here is like, if they're still doing any testing, they got to let the Commonwealth know. Great. She's not saying it can't be done. Like they can't be doing the testing or whatever. Right. But once they turn that over and give any deadlines and what have you, the Commonwealth may move for additional relief. So it leaves the door open for her to still say no to certain things potentially. The other thing too is she doesn't have to say this, right? She didn't have to include this. This is kind of like when she had her order as it pertains to Dr. Russell, right? And she added in all this stuff about how thorough the cross exam was and all the points that were made by Breenan and whatnot. And none of that was necessary when she's going to allow it in. This reminds me of that, where this doesn't need to be said. Of course, the Commonwealth they would have done it anyway. She doesn't have to give them permission. They would have done it anyway. So this to me is more like one of those things where she's like tipping her hat. It's like a nod to sort of like, how shall we say, like foreshadowing maybe, because it doesn't need to be said. Of course, they can file additional motions, right? They would have done that anyway. But the fact that she's saying that, I don't know. I just don't like that. I don't know. Do you guys see what that? I find that a little bit. Welcome, Carla. Happy Easter weekend. Love that everybody's green in the chat. So I don't know. I wouldn't be surprised, guys, if the defense complies with everything here and they turn everything over by the time that it says, and they have such and such testing or whatever, their results, and then Judge Bev is like, can't come in. I just wouldn't be surprised. And again, this would be like for rebuttal. It wouldn't mean they're not testifying, right? For the case in chief, but like, I just wouldn't be surprised because she has left this. Again, doesn't need to be said, but the fact that it's being said is a little bit of like, showing your hand or what have you. If that's how I personally interpret it. Let me know what you guys think she meant by this last line. All right, next up, moving right along. Commonwealth's motion regarding defense's opening statement. Oh boy. The Commonwealth moves for an order that defense counsel refrain from claiming in their opening statement that any of the victim's injuries were caused by any person or animal that was inside the home at 34 Fairview Road. Remember how the defense talked about how they were going to show one picture? I wonder if that one picture was his arm, John O'Keefe's arm. Based on the defense's request to show keep reading, Chelsea. Based on the defense's request to show the abrasions to the victim's arm in opening statement, the Commonwealth notes that the court has ruled the defense is precluded from mentioning any reference to third-party culprit claims prior to establishing a viable basis supported by admissible evidence, and any mention of third-party culprit claims relative to the abrasions would be improper. So here's my thoughts initially on this. That okay. I can see this going a number of ways. Like, we don't know what the defense would say. I mean, again, it sounds like, and I agree with, I believe it was Mr. Alessi who was arguing this at the hearing just the other day, that they don't want to say the dog was Chloe, right? Y'all heard that, right? We don't want to say it's Chloe. We don't want to say it's not Chloe. We don't want to talk about Chloe specifically, right? So as far as the bites, that was what I recall him saying. And now, having said that, we know that they do want to get into dog behavior, and that they do want to talk about Chloe, at least as it pertains. And I guess it would be in rebuttal, right? But as it pertains to with their other dog expert person, the what is it? Is it Lieutenant Wing maybe who was going to be that person to talk about civilian dogs that used to be canine and whatever, all that. I think it's fair that in rebuttal, if the Commonwealth wants to get into it, that the defense can get into that. It almost makes me want to go back and revisit that part of the hearing, because I recall, though, my recollection of Alessi making this argument in the hearing was that it was in general and not specific to only rebuttal. If indeed they were saying, Mr. Alessi was saying was like, we want to be able to, we might be able, we're going to talk about Chloe, right? But only in rebuttal, that would be dependent upon what comes in from the Commonwealth's expert, then they wouldn't be able to get into it. Nobody. Anyway, there's a lot of, welcome back, Truth Seeker. So I feel like it might be worth pulling up. I mean, the other thing is this, you could get into like semantics, right? Like if they're talking about a dog, but they're not naming the dog, but everybody knows which dog they're talking about. Like, that's kind of where I see this going, at least for opening statements, where they reference, like, for example, they could show the picture of the arm and they could reference, that it's from a dog, right? That doesn't mean that wouldn't be specific to any person or animal that was inside 34 Fairview. Like, if they just show that picture and they're like, the evidence will show that this came from a dog, right? For example, then that's a way they could, if this is granted, as it's stated here from the Commonwealth, that's a way around it, right? That doesn't mean it's from Chloe. So I don't know. It'll be interesting. Is it going to be like there's a random dog and we're not saying who it is? Or is it like there's a dog inside 34 Fairview, but they're not going to say the name Chloe? You see what I mean? Like, there's a lot of ways that both sides could try to finagle, certain things in. Is it like, I kind of want to go back to that part in the hearing. Let me know what you guys think if you want to go revisit that part from the hearing, because again, even if both sides agree, we're not going to say the name Chloe. It's like, well, they still could get into it with like a dog that lived inside 34 Fairview, right? You know what I mean? And the jury doesn't even have to know the dog's name. They don't have to know the dog's name. If they're all talking about the same dog, it doesn't even matter, right? Anyway, let me know if you want to revisit that from the hearing. Okay, so next up we have the ruling on the motions that were heard at the hearing. Okay, so defendant's motion for reconsideration of the portion of the February 18th order denying defendant's motion to compel provide. Okay, lolliport videos, right? Allowed in part and denied in part. The Commonwealth has agreed to the motion insofar as it seeks to have a defense expert download a protected file pertaining to this case from the Canton Police Department. To the extent the motion seeks an order permitting the defense to forensically examine the entire police detective file, it is denied. That makes sense. They can't have the access to the entire file with all of the other cases, obviously. Commonwealth's renewed motion to exclude testimony of Garrett Wing, denied without prejudice. This means it can be brought again, right? When you see with prejudice, they can't bring the same motion again. Without prejudice means it can be filed again. After review of the expert witness report by Lieutenant Garrett Wing, I find that he appears to be qualified by experience to provide some help to the jury on some issues in dispute. If the Commonwealth still asserts that Wing lacks the qualifications necessary to provide expert opinion, it should renew its motion prior to Wing taking the witness stand. So this is actually a good ruling for the defense, right? So yeah, so Wing's coming in, guys, right? Unless the Commonwealth, again, this is one of those things, again, it doesn't need to be said. The Commonwealth knows they can do this. I don't know why she's putting that in here, but it looks like if that does happen, it'll just be a limited voir dire. And so, okay. Defendant's motion for reconsideration on the order denying the motion to exclude James Crosby, Dr. Crosby, as it were, allowed in part and denied in part. Dr. Crosby is clearly qualified as an expert, but he's precluded from testifying that his bite mark analysis excludes Chloe as the cause of the marks on the victim's arm. He is not precluded from testifying as to the anatomy of a canine mouth or of Chloe in particular, including the measurements to her mouth. So we can talk about Chloe's mouth. Okay, this kind of answers my question from the previous filing, which is like, okay, whatever Dr. Crosby can get into, it's going to change what the defense can get into, right? So I say rebuttal, not even in rebuttal, in their case in chief. So yeah, okay. So to rebut the Commonwealth, but it's not in rebuttal as in a rebuttal case, obviously. So they've been talking about it in rebuttal. I just wanted to be clear. It's in rebuttal to the Commonwealth expert, but it would be in their case in chief. So, so in other words, he can talk, Dr. Crosby can talk about the anatomy of a canine mouth or Chloe's mouth, like the measurements of her mouth. What he can't say is that he's able to exclude Chloe as the cause of the marks on the victim's arm. But the fact that he can talk about Chloe in particular, like the measurements of her mouth, again, that to me makes it very clear that then the defense should also be able to talk about Chloe. So all of my questions pertaining to the previous filing, I think you can throw those out the door. We'll come back to that here in a second, now that we have more information here. So so he's not precluded from testifying as to the anatomy of the canine mouth or of Chloe in particular, including the measurements of her mouth. To the extent there is a question as to what testimony the Commonwealth may elicit from Dr. Crosby to rebut any defense expert, it can be raised at trial. Let me see if there's anything else that will help us with that previous filing. So these have no objections. Commonwealth's notice of intention to introduce extrajudicial statements of defendant allowed. So, and they didn't object to that, I don't think anyway. Oh, right. They objected because of the reader. By the way, we're going to have another filing on that. To the extent that the defendant objects to the Commonwealth's use of an independent reader for text messages between the defendant and John O'Keefe, the defendant should submit her objection in writing. And we did hear her say that in the hearing, and we have that. That will be our next up filing. Defendant's motion for specific discovery allowed. The Commonwealth and the defendant have reached an agreement as to all remaining and disputed materials except for materials 3 and 4. Number 3 seeks any information, including any oral or written statements or communication of any witness suggesting a reluctance or refusal to testify in connection with this case. Number 4 seeks any information, including any oral or written statements or communication of any witness wherein a witness suggested a reluctance or refusal to cooperate. Though it is a close call, I hate it when she says that, arguably, this request is covered by the Massachusetts Rules of Criminal Procedure and should be provided. Therefore, as to number 3 and number 4, the motion is allowed. So the defense is entitled to this material. The Commonwealth must provide this information within 1 week. Okay. If the defense is scheduled, so in other words, she wanted to side with the Commonwealth, but she can't because the rules don't allow it, is what this says. If the witness is scheduled to testify prior to then, the Commonwealth must provide the information at least 1 day prior to the witness being called to testify. Well, a win is a win for sure. And by the way, welcome back, Mass Dad. And she said this before. Like, again, she said this with Dr. Russell. It's not necessary. It's just her showing her hand that she wants to side with the Commonwealth. Had she left out this part, though it is a close call, arguably, I wouldn't even thought she wanted to side with the Commonwealth with this motion in particular. But this part, she's like, though it is a close call, and then cites the rule that says she can't side with them. That's how this reads to me. All she needed to do is, after this part where she lists what those number 3 and number 4 seek, all she needed to do is say, as per this rule, citing the rule, it should be provided, period, right? This part, though it is a close call, arguably, right? That's where she's showing her hand, and it's just annoying. Okay, so wait, before we get into this next filing, I want to go back real quick to this one. So, okay, so in other words, we have more information that, going in the order that I have these, that Chloe's coming up. All right, so that means then, let me read this again. So they want to refrain the defense from claiming in their opening statement that any of the victims' injuries were caused by any person or animal that was inside the home at 34 Fairview Road. I mean, but the word cause, right? I mean, that's a whole can of worms, because Judge Bev has gone back on her own made up rule about causation. So just, what they're saying here is the defense is precluded from mentioning any reference to third-party culprit claims, right? Remember, Mr. Alessi said, this is from not the most recent hearing, but from the hearing before, Mr. Alessi said that he's doing opening statements and that he does not intend to raise any third party. He said that, but they want to show this picture. So I wonder if the defense is what they're planning on doing is, again, showing the picture and then just referencing it's from a dog, but not anything about the dog being inside the house, maybe? Because he did say, Mr. Alessi did say he wasn't planning on bringing up anything third-party culprit in the opening, right? So I think that's what he's going to do. I don't see Mr. Alessi as being someone who's going to try to skirt Judge Bev's, like, you know what I mean? Like toe the line or push the limit. I think he said that very definitively. So I wonder if that is what they're going to do, is they're going to say it's a dog and not go any further than that. So it'll be interesting to see what else comes out. Let her say what all she wants at this point. The defense folks knowing her language doesn't matter. Well, it matters because it annoys me. That's really all it is. I mean, it's like, even if you're biased, you don't have to make it so blatantly obvious that you're biased. You know what I mean? Did Chloe a lawyer up yet? I hope so. Right? Cuckoo, calling all squirrels. That's a great point. We could just ask him ourselves. Now, he wouldn't be able to answer that question, but yeah, that is a good thought. Shout out to Mr. Alessi, by the way. So I wouldn't be surprised if there's a defense filing in response to this any minute now. So as always, I'll keep my eye out for that, but let's carry on to the next one here. All right. This just came out. So as far as the whole theater in the courtroom, right, where they want to have who's going to play Karen Reed, right, that whole thing. It is wild to me that the Commonwealth is not going to just have, or just what they don't want, that they're asking to have someone besides Trooper Garino read it, right? Okay, but this is the objection in writing as requested by Judge Bev. So defendant's opposition to the Commonwealth's request for use of independent readers. Here comes the defendant, Karen Reed, in response to this court's request for a written objection in response to the Commonwealth's request to use independent readers with regard to reported text messages exchanged between John O'Keefe and Karen Reed. Commonwealth has not filed a specific motion. Right. Great point. And what's really interesting, so that she required the defense to file a specific objection in writing, but the Commonwealth didn't file one to begin with. The Commonwealth has not filed a specific motion nor provided any legal authority related to this request. Right. But recently expressed its intention to use independent readers to present electronic communications. Yeah, at the hearing. Shaking my head. Well, I mean, just because sometimes it takes a minute for me to see them, right? I 100 where I'm able to find documents, I get them over the weekend, every weekend, I feel like. I mean, so for them to get posted where I can see them is what I mean. Obviously, they aren't filing things over the weekend, but for them to become public. That's true with any case. There's always times where court filings, even if they are posted to a docket or whatever, it takes a couple days for it to get updated or whatever. So yeah, happens all the time. Random Girl says, I don't understand why digital forensics is such a foreign concept. What are you referencing there? Are you referencing the Lolliport videos, the computer? Okay, so background. On April 14th, for the first time in less than 10 days before the start of trial, the Commonwealth first introduced the idea of utilizing an independent reader, stating that it moves to provide notice that it intends to introduce the defendant's own statements without a witness or in some circumstances through a non-precipient witness reader. The Commonwealth's request was limited to a single vague sentence without any supporting legal authority and was not made until long after this court's deadline for the filing of motions in limine. Attorney Breenan again discussed the idea of using independent readers during the April 16th motion hearing, more specifically detailing the Commonwealth's desire to use independent readers to present various electronic communications between Miss Reed and Mr. O'Keefe. The defense quickly objected to this inappropriate theater, especially given the high probability that such a stage delivery could be unduly prejudicial against Miss Reed, footnote 1. Although Attorney Breenan stated, quote, there would be no inflection that would be inappropriate, end quote, the defense does not feel it is prudent to take that risk. Yeah, agreed. If a jury were to hear these messages read inaccurately, no sustained objection or striking from the record would successfully undo that damage. Yep, I also agree with that. Notably, at no point in its writings or oral arguments has the Commonwealth provided any legal authority or basis for its desired use of independent readers in this context, namely for the reading of text messages. Mass Dad says he gets them directly from the court's docket in real time. Are you able to, like, my understanding is like that I've tried to get them from the court's docket. My understanding is that even for attorneys, that is difficult. So unless you're an attorney in Massachusetts, I don't know how you're able to do that, but please share your secret with me if you feel so inclined. And then I too can get them from the docket in real time. I know that you can see when things are posted, but not have access to reading them. So just to make that clear, of course, I want to be able to read them. Random Girl asked a good question. Doesn't the Commonwealth's case fail if they argue they're dog bites, but not Chloe? Well, they're not going to argue that they are dog bites at all. They're going to say they are not dog bites, and that would include Chloe. That's how that's going to go. They're going to say, well, I don't know for sure. They're either going to go with, what is it? The grass, the frozen grass scratched his arm, or I think maybe the taillight is like what it's looking at, that the taillight cracked and did that damage to his arm. That's what I think they're going with. They're going with not a dog. Not a dog. Because I agree with you. If the Commonwealth did concede that they are dog bites at all, that would be huge. But that's why they're not going to concede that. And in any case, that's what the ruling said, that they're allowed to say that they aren't dog bites, but they're not allowed to say it's not Chloe. So does that make sense? Like they're going to argue it's not dog bites. Hopefully that does make sense. Okay, so argument. So electronic communications should be introduced in accordance with the standard procedure. In January 2024, during the first trial of the above captioned matter, electronic communications between Miss Reed and Mr. O'Keefe were introduced as evidence through the testimony of Trooper Garino. During his testimony, Trooper Garino authenticated the messages between Miss Reed and Mr. O'Keefe and read them into court record. This method of introducing electronic communications is entirely consistent with standard procedure in Massachusetts. And then there's another footnote here. Furthermore, Massachusetts courts have emphasized the importance of authenticating text messages before admitting them into evidence. TSN, this is a real case of the taillight wagging the dog. Yeah, brilliant. That was brilliant. Conversely, the Commonwealth has not provided any statutory, I didn't think it was lame DSN, any statutory authority, case law, procedural rules, or evidentiary rules that would support its suggested use of independent readers for the purposes of performing the electronic communications between a defendant and a deceased party, footnote 3. This carries over from the previous page. It is unclear how the timing of the Commonwealth's proposed use of the independent readers would comport with this requirement. Okay, footnote 3. Even though the Commonwealth failed to provide any supportive authority for its position, defense counsel made its best efforts to find any examples of the scenario in Massachusetts case law, but today has not identified any examples that would support the proposition that communications between a defendant and a deceased party should be introduced by way of independent readers. Well, I mean, this means that this should not be allowed for sure, if there's not case law to support it. I mean, without a doubt. The defendant strongly opposes the use of independent readers and favors the standard evidentiary and procedural methods for introducing this evidence. Independent readers are an inappropriate way to convey electronic communications. Yeah, can't rule that one out. I mean, did anyone test Jen's teeth? I mean, come on, right? Jen! You know, banshee bite marks. I call her that because the way she says Jen sounds like a banshee. Okay, so use of independent readers to introduce electronic communications, such as text messages, is per se improper. Text messages are not verbal conversations. They are written communications which speak for themselves. The theater of utilizing multiple individuals to perform a text message conversation, I love that they keep saying perform, because that is what it is not an accurate reflection of a text message conversation, even under the best circumstances, and putting aside concerns regarding tone, tenor, and timing. I'm still wondering if Mass Dad's going to share a secret for getting access to these documents in real time. I'm wondering if he's still here, if you're still listening. And you could always include those in the Discord if you felt so inclined. Why would you ever keep such a joke to yourself, random girl? We want to know your Jen McTooth joke. Okay, so the theater, did I read this part? Yes, I did. Putting aside concerns regarding tone, tenor, and timing. Okay, yes. The Commonwealth's proposed use of independent readers seeks to create evidence that never existed. With regard to text message exchanges, such as those between Miss Reed and Mr. O'Keefe, there was never a live conversation, yet the Commonwealth seeks to create one through its use of independent readers. This is manifestly prejudicial and is a due process violation. Traditionally, readers are used to reenact prior testimony that is unavailable to the jury, such as prior testimony of a deceased witness. And look, they have case law. Woo! We already read that footnote. Welcome, Heather. In those circumstances, readers serve to provide the jury with a facsimile of what they would have heard had the witnesses been available. That is not the situation at issue here, where the Commonwealth seeks to have independent readers reenact text messages as a verbal conversation that never took place. The best practice would be to present jurors with the text and allow them to read them themselves. But short of that, the common practice of having the text messages read into the record by way of the authenticating witness, Trooper Garino, is sufficient. And that's how it is always fucking done. Overall, the defendant strongly opposes the Commonwealth's proposed use of independent readers to properly reenact text messages that were never verbal conversations in the first place. I mean, the only thing I think that would be fair would be to have Lolly read it, because then it would just be like flatline, you know? That said, tone, tenor, and timing add another layer of concern. Tone and tenor of written messages is subjective and individualized. As such, presenting a written conversation as a verbal conversation, right, this is a great point. It's an inherently problematic. It's an inherently problematic way to convey this type of exchange, right? Because it was not a phone call, it was not a verbal conversation, it was in text messages. Presenting text messages by the way of the neutral reading of an authenticating witness, often with the visual aid of the screenshots of the messages themselves, is the most logical and neutral way to present these communications. For example, Agent Doug Hart on the stand in Idaho, having to read all of Lori and Chad's messages into the record, including being asked directly what the nickname for Chad's penis was. My favorite moment, one of my favorite trial moments of all time. With regard to timing, text messages that are not always sent in real time. Sorry, let me read that again. With regard to timing, text messages are not always sent in real time. Often, and specifically in the messages at issue here, minutes or hours pass between messages. There is no practical way to present these delays accurately. Great point. With multiple independent readers. Right, they would have to sit there for an hour and not talk to each other. As we assume the Commonwealth does not intend to make the jury sit for multiple hours between the reading of messages. Brilliant. What a good point as well. Also, I will say, I created this command for Brennan a long time ago. It's been sort of the running joke that Nightbot is finicky and some commands he chooses not to use, or sometimes they work and sometimes they don't. And the Brennan command has never worked up until I think it was 2 days ago, it finally worked. I took a screenshot of it and I'm glad I did, because literally to date, it stopped working again. And that's the one time it worked. And so I'm just testing it out to see if it will work. But it worked the one time, which is just so funny. We love you, Nightbot, little guy. Oh, okay. Hopefully it will work again by Tuesday, if not earlier. Thanks, Nightbot. Most importantly, we do not have to wonder if the authenticating witness of the messages would be capable of delivering these messages appropriately, as discussed by Attorney Jackson at the April 16th motion hearing and reiterated here. Trooper Garino's delivery in the first trial was perfectly adequate. Yeah, it was. I agree. It was very adequate and very even keeled and just very monotone. It stands to reason his delivery in the second trial would once again be perfectly adequate. Nightbot has pending trials being prosecuted by Brennan. As if I couldn't hate him anymore. Start a free Nightbot movement. I'll start that right away. Yeah, you didn't. So Candace didn't know that Brennan was Whitey Bulger's lawyer. I knew that. Funny, another South Carolina overlap there. Hashtag free Nightbot. Okay, so next page. Argument number 3. Independent readers presenting text messages violates fundamental rules of evidence and procedure. Use of independent readers to introduce text messages violates the best evidence rule. Oh, his little hands. I just love him so much. The Commonwealth's proposed use of independent readers to introduce text messages would also violate the fundamental principles underlying the best evidence rule. The best evidence rule requires that to prove the contents of a recording, or photograph, the original must be produced, or a sufficient excuse for its non-production must be provided. There's the case law for that one. Additionally, for the purposes of authentication, courts often rely on individuals with direct knowledge of the digital evidence, including police officers who extracted the messages. Yep, that's how it's generally done. This strongly aligns with the underlying principle of the best evidence rule that the proponent of the evidence must provide a foundation sufficient for a reasonable jury to find that the evidence is what it purports to be. Right. That's exactly why that's the person who reads the messages. Here, the Commonwealth proposes that independent readers present text messages instead of the readily available Trooper Garino, who is the primary proponent and authenticator of the text messages at issue. As such, we oppose this use of independent readers as not only unnecessary and prejudicial, but also as violative of the best evidence rule. Mass Dad, did you hear my question to you about the documents? And that is true. Alan did also represent Harvey Weinstein. Yep. Okay, then we have subsection B. Continuous presentation of text messages by independent readers is unnecessary and potentially procedurally unsound. Lastly, at the hearing on April 16th, Attorney Brennan asserted that it is not sufficient to simply have a state police officer who is not a witness to those text messages come in and read them continuously through the trial. As described in detail throughout this motion, we firmly disagree that it is not sufficient to have an authenticating state police officer present text message communications in a trial. Beyond that, though, Attorney Brennan's suggestion that these messages come in continuously throughout the trial and at different parts of the trial when they become relevant does not appear to be practical or procedurally sound. Footnote 4. Right, because what I'm wondering is, will the foundation have been laid, right? Additionally, where text messages have been admitted in evidence, there is no need or purpose for their repeated reading to the jury, as they will have ample time to review these communications along with the other evidence during deliberations, and counsel may reference them by citing to the record. I have a feeling they're going to try to get them in without laying the foundation. That's my thought. Regarding Trooper Garino specifically, during the April 16th hearing, Attorney Brennan suggested that bringing Trooper Garino back repeatedly would create the wrong impression. How so? Given that Trooper Garino was able to introduce the exact same messages with ease during his continuous days of testimony in the first trial, we can remain confused by the Commonwealth's concerns. Yeah, as do I. Bringing him back would create the wrong impression. I didn't even notice Brennan saying that, but I don't understand what that even means. Anyway, given the Commonwealth's failure to provide any legal foundation for utilizing independent readers, it is difficult to know how they intend to introduce text messages continuously and when they become relevant. Footnote 5. Did we already read footnote 5? No, we already read footnote 5. Okay. Regardless of procedural underpinnings, Ms. Reed opposes the idea of continuous introduction of messages in general, as it sounds bulky, inefficient, and unduly prejudicial. Right. So in other words, even if they were to have, like, essentially this, like, look, if you're going to have somebody read it, should be in your, I mean, they're going to, it should be Trooper Greeno. But to the extent that they still want to do this continuous and repeated bringing up of text messages, it either could be objected to. This is essentially what they're saying, right? Either A, for being cumulative, redundant, right? But even beyond that, bulky, inefficient, and unduly prejudicial. Like that's what we all see, right? Once the messages come in, the messages come in, and then they go back with the jury. They don't get brought up again over and over. They might be referenced in like opening statements and closing arguments, but they don't keep bringing them in and reading them. It is a very odd thing that Breenan is asking for here. It's interesting. Oh, due to your profession. Okay, got it. No, I wouldn't ask for your login information, of course. No. I just was wondering, because my understanding was that they're really hard to obtain immediately from the docket. And so it makes me wonder if you also, anyway, I'm not asking for your login. I just figured if you had the filings earlier, anyway, would never ask for anyone's login information, of course. But are you secretly a ninja assassin? Sorry, that's a Murdoch reference. Yeah, I would agree with that. I don't think she's going to allow it either. Couldn't agree more with this, though. 100% he is approaching it as a defense attorney. Yeah, definitely. Although, having said that, a defense attorney who also has forgotten, like, the struggles of defense attorneys, for example, in like getting discovery on time and in a correct fashion, and myriad other things. Like, there's been so many moments with him where I'm like, I don't know how he'll go back. Like, how would anyone hire him if they followed this, right? Like, the way that he has just completely trampled over so many huge issues that are, like, to say a huge issue is like an understatement, right? And trampled over Karen Reed's rights in so many different occasions is like, I don't know. It's like, how are you actually defend? Like, there's some defense attorneys who I think would not be able to do this. I'll give you an example, Bob Motta, where they wouldn't be able to like, I'm not saying he couldn't be a special prosecutor. What I'm saying is, if he was, he would be very fair to the defense, right? Not like, that's why I keep saying, it's like, what happened to him? Like, he started out the first hearing and second hearing reasonable, and then something he's been changing over time. It's been a very interesting road watching that progression going along. Yeah, it is a stupid request. Very stupid. And he would make more money as a defense attorney than he would with this, for sure. Yep. I don't know why he took the case either. It is very odd. I also love Bob and Allie. Yep. Yeah. I mean, it's so funny because Bob has said before, you guys have probably heard, it's like, in like the D for DNA, his DNA is like defense. I don't know that he said that exactly, but pretty much. And I'm sure like that's how I interpret what he says. And if he hasn't even said that verbatim, which he may have. I do remember him saying verbatim, I'm a straight D guy, which is really funny. He said that to Peter Tragos one time. But yeah, again, just to revisit this whole thing with the doc, it is, with getting access to these court filings, it is not like other cases. And in fact, it's really funny. I've seen other attorneys on LawTube. I say other attorneys, obviously y'all know I'm not an attorney, but I've seen attorneys on LawTube who, struggle as well with getting these documents, even though they are attorneys, but of course they're not Massachusetts attorneys. So I don't know, like I wish I had some way to get them in real time, but yeah, anyway. So long story short, wouldn't be surprised if, again, like, for example, we saw that there was a defense deadline. What was it for? Well, let me hold that thought and read the conclusion so we can be finished with this one. For the reasons set forth here, in the defendant respectfully requests that this honorable court prohibit the use of independent readers in trial. Okay, fine. So where was it here? Hang on. It was, no, wait. Right. For example, that this deadline was yesterday at 5 p.m. The defendant was to produce to the Commonwealth any outstanding discovery. And then they had another thing due at April 18th at 5 p.m. And like, I haven't seen anything about that, but I think there might have been another response. Let me see. Oh yeah, this one. I would imagine, because this came out like 2 days ago or something, like again, where it was available to the public. I would imagine that there was a pretty quick and immediate response to this from the defense, but I've not seen that yet. So that was another thing I was thinking. Like, so I wouldn't be surprised if they filed that yesterday, for example, or day before, but like it just hasn't become public yet. I don't know. Mass Dad, are you able to see on the docket and just let us, like, did they file a response to this already? I would be shocked if they didn't, because literally they have this long weekend and then they come in with opening statements. And this is about the opening statement. So I would, again, and also it's short. I would have expected an immediate filing. That's the thing. And I've not seen it yet. So, yeah, I wonder the same thing. Need some Z's. I know you're talking to Mass Dad, but I wonder the same thing, given that he would be taking a pay cut. There's got to be some other incentive here for him. Right. Yep. I agree. His defense attorney clients will dry up after this case. I think so as well. I mean, it's interesting, right? Like I said, like if I were somebody in Massachusetts charged with a crime and I was looking for a defense attorney and I saw any of this case since his involvement, I would definitely not hire. No way. Absolutely no way. From the first hearing where he got involved, what was that, in November, maybe? Fine. He was fine there. It all looked very promising. And then it just has been going downhill. Again, it's like, what happened to him? I just have to keep asking that question. Fender, welcome, welcome. How's your research going, my friend? Speaking of clients. But that is, again, like that is all that I have right now. I'll double check just in case there's not anything else that's popping up. Because again, I would have expected that a defense response to this one. I mean, again, it's probably there, but I just don't have it yet. You know what I mean? What was the 678? And this was 673, 679. It would probably be 680. This is the most recent one, so that I've seen. So let me see. Yeah, I'm not seeing it yet, guys. It's a bummer. But we will keep our eyes peeled as always for that. There's no 680. You mean, yeah, yet. I assume you mean, okay. Right. Got it. Now there could be like, we have 673. Like there are ones that are missing from what I, do we have a 674 or 675, 67? I think we already had a 78, right? Yeah, we did. That's 678. So 4, 5, 6, and 7, right, would be missing maybe from what I've seen. So maybe if they did file a response to this motion prior to filing this one, it's possible. Oh, interesting. So that's your friend's getting married. Oh my gosh, amazing. I'm sure it's going to be incredible because Indian weddings are amazing. Yeah, we read that earlier, but yeah, that was yeah, that's one of the ones that's the one that I'm referencing that I would have expected a defense filing pretty quickly on. So are you seeing anything else, Mass Dad? Are you seeing a 674, 5, 6, or 7? So also for anyone who is new or revisiting or whatever, here's a link to the Discord as well. And we do have a members only stream coming up. I'll put the link in the chat for that as well. Again, it's going to be trivia night. We're going to be doing famous quotes, first in history, movie trivia, musical theater trivia, trial trivia, and 90s music. Math Dad is emailing me. Okay, awesome. Thank you for that. Appreciate it. Thank you. Thank you. Thank you. Thank you. Thank you. He's calling them readers, but what he really wants is like theater, legit courtroom theater. And why does he want them? To make Karen Reed look bad, I would say, probably. I mean, that's the real reason. I think it's really funny how there is literally no authority like to support that this ever happens in Massachusetts either. I mean, you know, right, exactly. Well, ideally, right? Ideally. I mean, I am with Jackson from what he said in the hearing, which is like, yeah, do we all really believe that they're not going to have somebody who's, you know, it doesn't take much, right? When they're the way Trooper, I agree with like what they said here. Not, yeah, and not on this page, but in this filing. The way that Trooper Garino read it the first time was great. It was just very plain. He was like, not at all. There was literally no inflection. It was almost like he was bored, right? Great, perfect. That's what you want, right? Another example, again, like Doug Hart, you know, reading Lori and Chad's messages. He was on the stand for like hours reading all of their messages, including all the grab me by the storm stuff. And the way he read it is like so monotone, like grab me by this. I can't even do it. I'm too, yeah, I'm way too much of an expressive person. I can't even imitate it, but hopefully you guys heard it. But like he's reading these text messages that are like just beyond, and it's just so monotone and matter of fact. It's like exactly what you need for a trial. Okay, thank you. And welcome. Nice to meet you, Jonathan. Excellent. Thank you. Thank you. Can we have Microsoft Edge voice? I don't even know. What does that sound like? Do they have a voice? Does Microsoft Edge have a voice? You know, like my earlier, like I made a joke like Lolly. Lolly would work, right? I mean, you know, I guess they don't want the jury to fall asleep, you know, but also, again, we haven't paid homage to the Lolly Bird here in a hot minute, so let's do that real quick. There he is. Oh, I'm seeing your email here, Jonathan. And this is amazing. You say your grandfather was a Broadway producer. Well, okay. First things first. Then you would excel definitely at the upcoming trivia night, where one of the categories is musical theater trivia. But I just have to say, one of the reasons why that's a category is because there's a lot of Scroll friends here in the Scroll crew that love musical theater. But also, I did professional musical theater for years. And so I especially love that your grandfather was a Broadway producer and won a Tony. That is amazing. Have Alexa do it. Right? I forgot we had like what noise, if anything, is being made, and in reference to the noise, who, if anyone, with respect to the noise, is making it. Okay, let me see here. Thank you, Mass Dad, for that. When is the trivia night? So I was initially going to do the trivia night tomorrow night, which for you, Fender, is I don't even know when. Monday. I don't know. Fender's in India, so you know. Time conversions. But for me, I was thinking of doing it tomorrow. However, because opening statements, or sorry, oh my God, fuck. Closing arguments for Lori are on Monday. I have to just look and see how much time everything will take, because I want to prioritize for tomorrow night, or for tomorrow in general. I want to prioritize the Lori's Inner Circle live stream, where we're going to delve further into the inner circle. And I know some people have Easter plans, so trying to also like make sure people can be there for that, because I know there's a lot of people who are going to want to see that. So long story short, I was going to have the members only tomorrow night, but it may not be, because we need to make sure we can do the Lori stuff, since you know ahead. I mean, it doesn't have to be, but it would just make more sense ahead of closing arguments. You know what I mean? He also acted on Broadway. Oh my God, Music Man and West Side Story? No way. Oh my God. It's really funny, because I was just including in the trivia night something about 76 trombones, but also I love West Side Story. I love West Side Story so much. I never got to be in West Side Story, but I love West Side Story. I'm so jealous. My first role was Gretel, the youngest Von Trapp, in The Sound of Music. Saturday night, that would be tonight. Fender, you mean? As in like in some hours from now? It will not be then. The members only live stream would be it would be either Sunday night for me, but probably not. Just depends on the Lori thing. You're just saying, okay. I agree that his granddad sounds amazing. I think is he still alive? Can we be friends? That is awesome though. Oh my God. I will just say, I mean, y'all hear me. I burst into song all the time. So, and a lot of times it's from musicals. Like I'm always doing like name that tune. What was it? The one I did the other day, that nobody got, but I bet you might get it, Mass Dad. The other day, getting to know you, getting to know all about you. I don't think anyone named that one. And I had another one I was doing. Oh, yeah, I think it was Impossible for a Plain Yellow Pumpkin. That's the one I did the other day, too. Anyway, just classic. Nailed it. Good job. Nailed it. You'll be great at the trivia. Monday night, are you saying your time, Fender, or my time? Yep. Good job. Ooh, this would be fun. So Mass Dad's gonna kill it at in the musical theater department. That is awesome, dude. I love it. Oh, I'm sorry to hear that. He passed away at 97 years old. Wow. Monday night, my time. I don't think it will be Fender. Are you able to use your phone on the flight? That's awesome though. I freaking love. Mass Dad, are you familiar with the Secret Garden at all? Because I had so Elon University, which is hello Meg, which is in North Carolina, has one of the best musical theater programs for college. And I was lucky enough when I was in 7th grade, they did the Secret Garden, and I got to play Mary. And so a lot of the kids who I say kids, they seemed old to me at the time, and now they're kids. They were college kids, right? That were in that production, are like have been and are now on Broadway for like all kinds of shows, and have like the leading roles. And they were like, it's funny because they were like supporting cast for that, but that was so much fun. Okay, gotcha. It's a great show. It's a great show. It's a good one. Um, Great song, great music. Oh my gosh, I could go on and on. Oh, interesting. Okay, Fender. So Meg, how was your Easter egg hunt? And who was it that was making a carrot cake? Random girl. Are you still listening? And how is your carrot cake going? So, yeah, I could talk music theater forever. But we don't have any other Karen docs, guys. So that's going to be it for this live stream. Next live stream will be our bonus round for Welcome Official. People are getting here. Where will be our bonus round for Alex on Cross. For anyone who missed it, Dateline is being a dick to Court TV, basically. And because of that, we're going to be watching Alex on Cross Day 22 bonus round. But this time we're going to get additional and alternate camera angles. So it's going to be epic as fuck. And we're gonna include our chicken business series and our What the Truck series. It's going to be amazing. And that'll be tonight. And then again, I'm still working out what the timing of everything tomorrow. But yeah. So, and then of course, as you guys know, Tuesday is Karen Reed. I don't know what ever became of the whole thing about Alan Jackson's arrest. I don't know what happened there because Mandy's a really reliable source. I don't know if she saw something that looked like a legit warrant that wasn't. I really don't know. I've still not gotten any follow-up on that, but I just wanted to say that for anyone who's there for that moment, I don't know what happened. I never got any follow-up. I can't find anything. And I don't know if somebody just if fabricated something that looked realistic enough, but anywho. No. It was, don't worry, Fender. Don't worry. That was was that yesterday? Somebody who has a connection to someone with close ties to be able to get documents. I don't know who they are. It's like she's got a connection, and her connection provides documents, and then she provides them to me when I need something sometimes. But anyway, she said that this just happened and no one has it yet except for this anyway. But there was a warrant. I just don't know what happened of it. So yeah, happy Annie, thank you. So she was there 2 days ago, right? Yeah, I just don't know what happened. Like Miss Mandy isn't making shit up. Like I can tell you that for sure. So whatever it was must have been, I have no idea. But she said that like it just happened and she was going to send it to me, and she was trying to get it loaded on the computer, but her computer was taking forever. But she even referenced case law and all anyway, but then I never got it. And I haven't heard back from her, and I've searched and I can't find it. Anyway, Matt's dad might maybe know if it's a thing. Yeah, right. Exactly. The world, everything would be blowing up if this happened. So I just don't really know what became of that, but I just wanted to yeah, I think it was a mistake as well. Happy Annie. Yeah, I think it must have been. So, so anyway, but y'all, that'll be it for this live stream. The Lolly Bird is still up there. Oh my God, squawk. Anyway, but I love you guys. Welcome to all the new members. We'll keep you guys posted as for the members only live stream. Remember, in the Discord, there is a thread for members only requests and recommendations. And I also will keep updates there too, as to when we're going to be doing our next live streams. So for anyone who hasn't checked out the Discord, highly recommend. And, but until next time, love you guys. Squirrel Crew's the best, and I'll see y'all next time. Squirrel out.